Welcome to Amorit Education Explainer. Thank you for joining us. Today, we're looking at an important immigration and HR compliance development that could have a very real impact on sponsored hiring, compensation planning, and workforce budgeting. If your organization hires or sponsors foreign national talent, this is one of those proposals you do not want to ignore. What the Department of Labor has proposed is a major change to how prevailing wages would be calculated for H-1B, H-1B1, E-3, and PERM cases. And if this rule is finalized, it could push required wage floors higher across many occupations and locations. So in this session, I'm going to walk you through what changed, who could be affected, when it could apply, and most importantly, what HR teams should start doing now without overreacting. And one important reminder right at the start. This is still a proposal. It is not final yet. So the goal today is to help you prepare intelligently, not panic. Let's start with the big picture. The headline here is simple. The Department of Labor is proposing a much higher four-tier wage structure for the prevailing wages used in LCA-based programs like H-1B, H-1B1, and E-3, as well as PERM labor certification cases. In practical terms, that means the minimum wage floor tied to a role and location could move up significantly if the proposal becomes final. Now, why does that matter for HR? Because these wage floors affect real business decisions. They affect whether an offer can move forward, whether a compensation band still works, whether a PERM case remains financially viable, and whether budgets built around current assumptions still hold up. The DOL also estimates an average increase of about $14,000 per worker per year under its model. That does not mean every case goes up by that exact number, but it gives you a sense of the direction and potential size of impact. So the immediate HR concern is this. If your team has been relying on current level 1 or level 2 wage assumptions for new sponsored hires or new PERM filings, those assumptions may not hold if the rule is finalized. Before we go deeper, let's make sure we're all grounded on what prevailing wage actually means from an HR perspective. In simple terms, prevailing wage is the required wage floor for a specific occupation in a specific geographic area. For H-1B, H-1B1, and E-3, the employer generally has to pay the higher of two numbers: the actual wage paid to similarly qualified workers in the organization, or the prevailing wage for that occupation and location. For PERM, the job being sponsored has to be offered at or above the prevailing wage as part of the labor certification process. So this is not just an immigration issue sitting off to the side. HR touches this all over the place. It shows up in job leveling, compensation bands, offer approvals, budgeting, LCA coordination, PERM timing, and payroll setup. That's why this proposal matters operationally. It affects the full hiring workflow, not just the legal filing step. Now, let's get to the heart of the proposal. What DOL wants to change is the percentile level used for each wage tier under the prevailing wage framework. Right now, the wage levels are based on lower percentile points. Under the proposal, those percentile benchmarks would move up quite sharply. Level 1 would move from the 17th percentile to the 34th percentile. Level 2 would move from the 34th to the 52nd percentile. Level 3 would move from the 50th to the 70th percentile. And level 4 would move from the 67th to the 88th percentile. The practical meaning is straightforward. Higher percentile usually means a higher wage floor for the same role in the same market. And for HR teams, that means a role you currently view as manageable within the existing wage framework may become more expensive under the proposed one. So this is not a technical adjustment in the background. It can translate into real offer pressure, real band pressure, and real budget pressure. The next question is the one most HR teams ask right away. When would this actually apply? As of now, this is a Notice of Proposed Rulemaking. The proposal was announced on March 26, 2026, published in the Federal Register on March 27, 2026, and the current public comment deadline is May 26, 2026. But there is no final rule yet, which means there is no final effective date yet either. That part is very important. So right now, you should be planning scenarios, not treating these new wage percentiles as already in effect. Based on the proposal, the changes would mainly apply to certain pending or future prevailing wage determinations, as well as certain new LCAs and new PERM-related filings, depending on timing and how the wage source is used. The clean HR takeaway is this: focus on new filings and upcoming cases, not on assuming that every existing case immediately changes. Let's talk about money, because that is where this gets very real very quickly. DOL's proposal includes a modeled estimate that the average certified wage could increase by about $14,000 per worker per year. Now, I would not present that number internally as a guaranteed increase for every case. That would be too simplistic. Think of it as a planning signal, not a fixed outcome. The actual impact will depend on the role, the location, the wage level, the wage source, and how close your current pay practices are to the new proposed floors. Where HR tends to feel the pressure most is when offers were built near current level 1 or level 2 assumptions, especially in higher cost markets or in job families where internal bands are already tight. So this is really a forecasting issue as much as it is a compliance issue. HR, compensation, and finance need to be aligned early. Not every employer will feel this the same way. The organizations most exposed are usually the ones with a high volume of new sponsored hires, a meaningful PERM pipeline, or compensation structures that leave very little room above current wage floors. Startups and smaller employers may feel this especially hard because they often have less flexibility in compensation budgets. Early career sponsored roles can also be vulnerable because those are the roles where level 1 and level 2 assumptions often matter the most. So if you are trying to prioritize where to look first, I would start with a few very practical buckets. Look at open roles that are likely to involve sponsorship. Look at job families that are commonly filed at wage level 1 or 2. Look at higher cost locations or wage volatile markets. And look at PERM cases you expect to launch for current employees. That gives you a focused risk scan instead of a broad, unfocused reaction. This is where the proposal becomes a true cross-functional HR issue. For talent acquisition, the big issue is offer viability. Recruiters may find that a range that looked fine before no longer clears the required wage floor for a sponsored candidate. For compensation and total rewards, the issue is whether current bands and leveling structures still make sense, especially for common sponsored roles. For mobility or immigration teams, the issue is case strategy. Timing, location, job design, wage source selection, and filing approach may all need a closer look. For payroll and HR operations, the concern is execution. If higher required wages come into play, those changes need to be reflected accurately in payroll setup and compliance documentation. And for finance and workforce planning, the question becomes whether hiring plans, department budgets, and headcount assumptions still work if sponsored roles cost more than expected. So this is not one team's issue. It is a connected workflow issue across HR. Let's make this more concrete with a few examples. First, imagine an entry-level software role where the offer range was built close to the current level 1 wage floor. If level 1 moves higher under a final rule, HR may have to increase the salary range, revisit the job level, or decide that sponsorship for that particular requisition no longer makes sense under current budget constraints. Now take a more senior role, like a principal data scientist. If the required wage floor moves higher at the upper wage levels, the company may need to revisit whether the current compensation band, exception process, and approval structure are still workable for that type of hire. And then think about PERM for a current employee. If HR is planning a PERM filing and the offered wage has to meet a higher prevailing wage standard, compensation timing becomes critical. That may mean aligning immigration planning with merit cycles, promotions, or off-cycle pay decisions. These are exactly the kinds of decision points HR should start thinking through now. So what should HR do now? The first step is to avoid two extremes. Do not ignore this proposal, but also do not act as though it is already final. A good approach over the next 30 days is to create a small working group across HR, immigration or mobility, compensation, and finance. Then inventory your likely sponsored hiring pipeline for the next 6 to 12 months. Identify which roles, locations, and cases are most exposed. After that, build a wage floor checkpoint into the offer process for roles that are likely to involve sponsorship. Over the following 30 to 90 days, start modeling cost scenarios. Look at best case, mid case, and higher impact case. Stress test the compensation bands that matter most. Update recruiting playbooks so recruiters and hiring managers are not caught off guard. And then, if the rule is finalized, that is when you move from planning into execution. Updating comp structures, refreshing intake forms, retraining stakeholders, and tightening payroll and documentation controls. That is the right sequence. Prepare now, execute later if needed. One thing HR will need here is a very clear message for leaders and hiring managers. The plain English version is this. The Department of Labor has proposed raising the wage floors used in key sponsored hiring and permanent residency processes. It is not final yet, but if it becomes final, new sponsored hires and new PERM filings may require higher salaries than teams are currently expecting for the same role and location. That is the message. Leadership should expect HR to come back with a list of the most exposed roles, updated approval guardrails, and budget scenarios. And HR, in turn, will need a few things from leadership: earlier notice about likely sponsorship, flexibility around level and location where possible, and timely decisions when compensation exceptions need review. This is one of those moments where early communication prevents a lot of downstream friction. Operationally, there are a few controls that make a big difference. First, define ownership clearly. Who is responsible for checking prevailing wage assumptions before an offer goes out or before a filing moves forward? Is that immigration, talent acquisition, compensation, or a shared process? That needs to be clear. Second, make sure job descriptions, leveling, and actual duties are aligned. Inconsistencies between HR systems and immigration records create risk very quickly. Third, tighten documentation. Keep clean records of approvals, assumptions, effective dates, and any exceptions. And fourth, train the people closest to the process. Recruiters, HR business partners, compensation partners, and hiring managers all need to understand when wage floors matter and why. Good governance here is not about adding bureaucracy. It is about avoiding preventable problems. Let me close with the most important bottom line message. What we have today is a serious proposal, not a final rule. But it is serious enough that HR teams should absolutely start preparing now. The core facts to monitor are the same ones we covered today: the programs in scope, the proposed wage percentile increases, the potential effect on new sponsored hires and new PERM filings, and the official rulemaking timeline. For now, the best approach is to monitor the Federal Register docket, follow DOL updates, coordinate closely with Immigration Counsel, and prepare internal scenarios so your team is not scrambling later. If the rule is finalized, the organizations that will handle it best are the ones that used this proposal period to get organized early. Thank you for joining Amorit Education Explainer. I hope this gave you a clear, practical HR view of what this proposal could mean and how to prepare for it thoughtfully.